It is the same procedure that is done thousands and thousands of times around the world every day for patients, living patients who are going to be revived later or who will regain consciousness later for surgery. It's simply carried to extreme. Now, how that can be considered cruel and unusual, I have no idea.
If the states are ever to resume killing this way again, they'll have to make sure that there are no more high-profile errors, and that it cannot be proved to be a cruel and unusual punishment. How can that be done? California, here I come, because here a federal judge has wrestled with just this problem, and thought he'd found a solution.
Quentin over there.
2 years ago, a convicted killer called Michael Morales left his small prison cell and took a walk to the death house, ready to face the ultimate punishment here in San Quentin.
Morales was convicted of killing 17-year-old Terry Winchell in 1981 of Lodi.
Morales raped and killed in 1981.
Michael Morales was convicted of murdering a 17-year-old, Terry Winchell, the girlfriend of his gay lover. According to prosecutors, Morales first tried to strangle her, then beat her with a hammer, and raped and stabbed her.
This is as close as we're going to get to Michael Morales. The cell's behind that door there. This is where he lives his life in San Quentin prison.
Because he survived the night he was meant to die. We couldn't ask him about what happened, because under California state law, death row inmates can't be filmed.
Good afternoon. We're from BBC TV. Nice to meet you. We're doing a film about lethal injection as a method of execution and the argument about Michael Morales. So he's still alive.
There'd be more punishment living up there than dying. Dying would be the easy way out, if you ask me.
You think being in prison is the worst punishment?
Of course. I'd rather be dead than live up there in death row the rest of my days waiting to get killed.
He's a piece of junk. I mean, if you use a hammer on a 16-year-old child, come on. I mean, I don't feel for him. Put him in my cell for an hour, and I'll show him cruel and unusual punishment.
Through there, behind that brown door there, and that's where Michael Morales was meant to die. The former gas chamber adapted for use for lethal injection.
There was a history of serious problems with the lethal injections that had happened here, and Morales' lawyer said this was no place to kill his client. Dave Sr. argued that his Eighth Amendment rights would be at risk.
There was 2 executions in California in the 6 weeks before Michael Morales was scheduled to be executed. Both of those executions, according to the protocol, took an inordinate amount of time. The drug should be administered and the inmate should be dead in 3 to 4 minutes. Instead, it was taking a half an hour.
Half an hour? That sound at all familiar? In an attempt to get the execution halted, Morales' lawyer took his case before a federal judge.
We thought it would be interesting to ask the judge what he thought. I thought for a minute he'd speak to us, but this is America. Can we speak to you, Judge Jeremy Fogel? Yeah, okay. Judge Jeremy Fogel, thank you very much indeed for letting us come to see you. We very much appreciate it.
This is my courtroom. This is the bench where I sit.
Is this where the lawyer for Michael Morales came to plead for his life?
Yeah.
Came to plead the Eighth Amendment?
Right here. In the Morales case, I had the records of all 11 lethal injection executions in California. There were 6 of 11 executions in which there were unanswered questions as to whether the inmate had been anesthetized because there were vital signs shown in the records that were inconsistent with unconsciousness. Mr. Morales had presented enough evidence to raise a substantial doubt as to whether the protocol was functioning properly.
So the judge agreed there was an Eighth Amendment risk. The state of California respectfully disagreed about their record, but the case was lodged.
Hi. Are you Dan Gillette?
I am.
Chief Assistant Attorney General Dane Gillette had his own interpretation of what cruel and unusual punishment should mean.
We've never conceded that there is any evidence that any California inmate who's been executed by lethal injection suffered in any way that could be considered a violation of the Eighth Amendment. The key is there cannot be an unreasonable risk of the infliction of undue or wanton pain. That doesn't mean there can't be any risk. It means that you're not doing a procedure that you know is going to cause cruel and unusual punishment, meaning excruciating pain.
So you don't think the legal test should be, it must be painless?
Absolutely not. Being absolutely painless has never been a suggestion as a required part of the Eighth Amendment.
A jury had tried Morales, and he'd been sentenced to death. How could the state now carry out that sentence without the Constitution being breached?
The constitutional violation would be if he was conscious when he was injected with the third drug.
And what was your resolution?
I said you can have trained people monitor Mr. Morales' level of consciousness and speak up essentially if it turned out that he wasn't unconscious.
The judge specified that medically qualified people experienced in the field of anesthesiology should be in the execution chamber.
We had anesthesiologists who were prepared to do that. We believed that we had complied fully with the requirements that he'd set forth, and they knew exactly what was requested of them.